Hello, everyone. Thanks so much for joining us today for our webinar, Best Practices in Maximizing Patient Safety Privilege Protections Through Policy Development. We really appreciate you joining us. I'm Sharon Beckwith. I'm the SVP and GM over peer review and clinical quality consulting at the Hardenberg Group, which is a Centac company, and I'll be moderating today's program. Just a quick note on the Centac name and organization. You may or may not have seen our press release that came out on Monday and our new website that launched, but we are rebranding the organization. We're very excited about what we've built. So please take a moment to take a look at that press release if you hadn't had a chance to already. Today's webinar is being sponsored and hosted by the Hardenberg Group, a Centac company. So we're going to go ahead and get into just some simple housekeeping items. All attendees, your microphones have been muted. And please go ahead and put your questions into the Q&A icon. Just depending on how your screen is set up, it may be at the top of your screen, it may be at the bottom of your screen. But if you can go ahead and type your questions into Q&A, that'd be great. And then as we get towards the end of the webinar, our speakers are going to leave some time to go ahead and address those questions. We are providing CME for this presentation, so we're required to inform you that we have no disclosures, and we're also providing NAMS credit. So again, NAMS continuing education credit will be emailed to you directly from your in the thank you for attending follow-up, which will come from the Hardenberg Group email. So you'll see that come through shortly after the webinar, and also included in the email will be slides from today's presentation. I think there's an additional attachment from our speakers and a link to a short survey. For all speakers, we would really, or for all attendees, I should say, we would really appreciate if you gave us your feedback. It really does mean a lot to us and helps us also look at other topics that are of interest to our attendees. Again, this is our just simple disclosure slide. Neither Michael Callahan or Ellen Flynn have any conflicts to report on the presentation they're doing today. And again, another disclosure slide that we are required to submit as a PSO. So your speakers today, I'm really pleased to introduce Michael Callahan. I think a lot of you probably already know Michael. He has been in our industry for over 40 years, and just based on the amount of content we have today, I'm just going to scoot through these quickly, and you've got his full bio if you'd like to see it, as well as his contact information. And then Ellen Flynn is our SVP over our PSO. And again, we've got Ellen's full bio here. Many of you may be very familiar with Ellen as well. Her contact information is here, and her full bio is available. So thank you so much both for joining us today and sharing your knowledge and expertise. And with that, I'm going to go ahead and kick it over to Michael to get started.
All right, Sharon, thanks so much. And welcome, everybody. It's a pleasure to have this opportunity to give what we think is a very important presentation. It's interesting. We have over 900 registrants, and they include chief medical officers, chiefs of staffs, department chairs, professionals working in the quality and risk management space, additional physicians, we have attorneys, we even have other patient safety organizations, and of course, MSPs. And the reality is all of you, every single person on this call and many within your own organizations play a key role in efforts to improve patient care, improve quality outcomes, and to reduce risk. But that said, since our focus is going to be on the Patient Safety and Quality Improvement Act of 2005, I think Ellen and I would wager that many of you may not even be aware if your organization is in a ARC certified patient safety organization, which as a member gives you access to very broad privilege protections that cover all sorts of activities that we're going to be addressing. Not only that, even if you know you're in a patient safety organization, do you know the name of the patient safety organization? I bring this up because Ellen and I have been working in this space for years and years and years, and it is amazing how individuals, such as everyone on this call, is not even familiar with the Patient Safety Act. They don't know if they're in a patient safety organization. Moreover, they don't know necessarily if they have what is called a patient safety evaluation system policy, a PSES policy, which is critical because it's the document that identifies what privilege information is being collected, how is it being generated, how is it being shared in the organization through various committees, various processes, various procedures, in your efforts to identify when adverse events occur, what was the cause of those events? Did it go down a peer review path? Did you create an root cause analysis or similar analysis? And if you don't know what you're engaged in, or if you don't know the scope of the privilege protections, how do you adequately do your job? I mean, MSPs, for example, they're the gatekeeper, right, of quality. They assist department chairs in appointment, reappointment, OPPE reviews. They gather the information, they make it available, they attend committees, as do physicians, as do other people in the quality and the risk space. And those activities can all be privileged and confidential, not just under your state law, because you're probably very familiar with your state law, but probably not familiar with what's being protected under the PSES policies. Because all hospitals at this point in time are in a PSO and maybe multiple PSOs. And Ellen and I have found it kind of amazing how people don't understand what the processes are, don't understand that they're handling privileged information because they've not been trained, they've not been educated, or they've not reviewed their PSCS policy because they don't even know that there is one. So our focus is to try to familiarize or refamiliarize everyone on this call with some of the key terms, the key definitions, the impact it has on operations, within the hospital, the health system, the physician group, whatever licensed entity is participating in a PSO. Ellen is then going to focus on the patient safety evaluation system. What is it? What are the policies? The importance of the policies? How do you then develop and further develop your policies so that you can expand the scope of protections that are offered under the Patient Safety Act? In addition to the slides that you'll be getting after this presentation, you're also going to get an example patient safety evaluation system policy that we helped develop for a multi-hospital health system in New York. Quite honestly, when you see that, you probably will be blown away because one of the to-dos that we'll talk about is you need to look at your existing policy, especially if you haven't seen it, and compare it to the one that you're getting. You will see how broad the privilege protections are under the Patient Safety Act. And the more you know, the more you can contribute because all of you, again, have a role one way or the other of improving patient safety and reducing risk. So these were the learning objectives, both for NAMS. I kind of went over that, same for the CMEs for the physicians. So the purpose of the Patient Safety and Quality Improvement Act was a recognition by Congress that as providers are being expected to improve outcomes, improve patient care, reduce risk, passage of a broad privilege protection in a voluntary program, somewhat voluntary, since under the structural measures that some of you may be aware of, hospitals have to be in a PSO. We need to create a safe environment, a protected space in order to have the kinds of quality, risk, peer-reviewed discussions necessary to improve patient care. And as you're in a protected space at all the different levels of the committees, all the activities engaged in improving patient care, reducing risk, when everyone knows it's privileged, it's confidential, it's not subject to discovery or admissibility in the evidence, people are more open to being upfront, being objective, to have these necessary discussions. And as we'll talk about, it's information that can be shared throughout the system, can be shared with other providers, and the privilege protections uniquely apply in all state and all federal proceedings. Your state privilege protections only apply at the state level. So quickly, the reason I'd list some of these areas is because if you look at HIPAA, COVID, accreditation compliance, certainly med malpractice, negligent credentialing, peer review, and privileged information is involved in all of these particular activities. And so we think of the privilege protections applying in medical malpractice, negligent credentialing, where obviously the plaintiff is trying to get access to anything under the sun to help them prove their negligence claim against a hospital and physician groups and other providers. It's also privileged information in all these other categories, peer-reviewed disciplinary lawsuits, for example. And knowing again what is privileged, not just under the state statute, which you all are probably familiar with, what's privileged under the Patient Safety Act is key in all of these areas of potential liability exposure. Moreover, providers are being paid based on value, not based on volume. If you got a physician who has a high readmission rate and is causing the hospital to be penalized, okay, why is that happening? What's wrong with Dr. Callahan? Why is his readmission rate so high that's dragging down the numbers? You can do and should be doing an evaluation of that, which can be conducted in a privileged space. And of course, as you all know, everyone through competition is being rated as, by various agencies. Oh, we're in the top 10 of cardiac care or whatever. You see these ads all the time. And because being able to be perceived as a high quality facility is important. I should point out in a recent Office of Inspector General report that was published in September, the OIG has taken the position or believes that hospitals miss 50% of the adverse events that are occurring within their facilities. So they're not being identified, they're not being evaluated. And consequently, the so-called improvement in outcome that is being expected and supported by the Patient Safety Act is not happening. And that's the perception that government has in terms of, our hospitals and other facilities really doing the job of rolling up their sleeves and engaging in efforts to improve patient care. So some key terms and definitions. Patient safety work product is the term that we use for the privileged information under the Act. And let's just go through that first bullet point. Any data, any reports, any records, any memoranda, any analyses such as RCAs or written or oral statements, which could improve patient safety, healthcare quality, or healthcare outcomes. That's everything providers do, right? That's their main job. That's their main business. And so when you think about what are all the activities, and we'll unpack that a little bit more, that are being utilized within any provider, health system, hospital, physician group, surgery center, any licensed entity to improve patient care, you can just think off the top of your head all the different committees, the reports, the analyses that are being undertaken to achieve those improvements, okay? And when you're in a PSO, you're either reporting adverse events, safety events, incident reports to a PSO, or you are conducting, if you look at that last bullet point, different kinds of deliberations or analyses, for example, at a peer review committee, quality committee. And in the design of your policy that Ellen's going to talk about, you identify what you're reporting to a PSO, what are you treating as deliberations or analysis. The example policy we're sending to you, it goes on for pages of identifying what are that system treating as privileged, and most of it falls into the deliberations or analysis bucket, so to speak. Hospitals don't send committee minutes to PSOs. PSOs don't want committee minutes, okay? Yet it can be kept privileged within your facility. Again, this is just kind of a graphic portrayal of what I just talked about. It can be data. Look at all the data you're creating in your dashboards, in an attempt to track outcomes, to track comparisons among physicians or even hospitals within your systems as to how they're achieving certain outcomes. Who are the outliers? Who's leading the pack in quality? Those kinds of discussions, memorandums, deliberations, written statements, minutes, emails, all of that relating to improving patient care can be kept privileged and confidential. But not everything is privileged, right? And you have to be careful about overstating what you're trying to keep privileged. So obviously, medical medical records are never going to be privileged under state law or the Patient Safety Act. Original billing discharge information, other original information. Um, and of course, you look to the last bullet point. Many states, such as New York, Texas, California, others, have mandated reports. So if there is an unexpected death, wrong site surgery, operating on the wrong patient, every state has its different categories which require a mandated report, which typically are on a form and typically factual. Okay, some states may require you submit an RCA. I think those are few and far between under certain circumstances. But the analysis that triggered that mandated report can and should be kept privileged and identified within your policies as being privileged and confidential patient safety work product, okay? Which again is not subject to delivery, to discovery or admissibility into evidence. Again, this is just a graphic portrayal of what I just talked about. So there's some other key terms. That one of the benefits of the Patient Safety Act is that it applies to all licensed healthcare facilities or providers who can provide healthcare services under state laws. And so think about it. If you're in a large system, you have hospitals, you may have SNFs, physician groups, labs, pharmacies, nursing homes. All of those are licensed entities that therefore can all take advantage of the privilege protections within a healthcare system that's in a PSO. Moreover, the corporate parent or the sole shareholder, depending on your system, even though it's not a licensed provider, is considered a provider if it owns, controls, manages, or has veto authority over a licensed provider. And therefore, the parent can either generate privileged information, can receive privileged information, patient safety work product. It's not a waiver. There is no waiver under the Patient Safety Act. While there are waivers in state statutes if that privileged information is disclosed outside of a committee structure. Okay. Um, and this leads to the next slide, the next few slides. So look at patient safety activities. This is actually wording that comes out of the Patient Safety Act. Okay. So if you look at each of these activities, you should be thinking about, okay, what are the activities, the committees, the initiatives, reactive, proactive, that we use to improve patient safety? You know, what is the work product? What is the analysis that's being conducted over that information? How is it being used and disseminated to improve patient safety, to identify good and best practices or bad practices? Um, and again, utilizing within a just culture of safety, to improve patient care. And so throughout this presentation, we want you to be thinking about, okay, what are those activities? What are those committees? What are those reports, those analyses that, aren't in our PSES policy that should be in your policy? Because now you can claim protection over those activities to create that safe space, but also to protect information from being subject to discovery. And this is just another continuation of activities. Next slide. So as we talked about, the parent organization, the corporate parent that owns, controls, or manages a healthcare provider within its system, that entity can also take advantage of the privilege protections, not just the hospital. Okay. And so we've had the opportunity to look at some complex organizational org charts because you've got layers, you've got a corporate parent, you might have regional sub-parents, and under those regional corporations, you have hospitals and other healthcare providers. Depending on the structure, all of those entities can obtain protection under the Act. And leading to the next slide, one of the other great benefits of this statute is that those entities, that system that I just briefly described, are considered affiliated providers. And the advantage of being an affiliated provider under the Act is all of the privileged information that's generated. So let's say you got 5 hospitals, right? And you might have overlapping medical staff members at some of those hospitals, but you want to be able to track outcomes. You want to be able to track quality. You want to be able to track information and share that across those 5 hospitals. Okay. Because you're trying to develop continuity of care, standardization. If Callahan's on 3 of those medical staffs and Callahan is having some peer review issues, you want to be able to share Callahan's information because you can't let me do privileges at one of the hospitals, and let's say they get restricted, they should be restricted then at the other hospitals where I have medical staff membership. Okay. And so being an affiliated provider is advantageous, especially let's say you're in a system and you got a patient that went to a primary care group uh, and then had complications, that went into the hospital, was treated by a surgeon, was then discharged to a skilled nursing facility because of other complications. You want to track all of those quality information, adverse events that may have occurred, which you can do under the Patient Safety Act because these would be affiliated providers. Use is an important concept, and the confusion is, so patient safety work product, privileged information that's generated can be used for any purpose, okay, within that entity. Okay, you get courts, you get lawyers arguing, well, you didn't keep it within your patient safety evaluation system policy. You use it for training and education purposes or peer review purposes. And maybe peer review wasn't even identified in your policy. That's permitted. It's not a disclosure. You don't lose the privilege protection. So you can specifically use it for any purpose within that entity. And once you start sharing outside the entity, that's when you need a disclosure exception, like sharing among affiliated providers. Disclosure is, and in your policies that you have, they probably list all the different disclosure exceptions. You have to fall into a disclosure exception in order to release PSWP. So, for example, I'm an independent contractor. I get PHI, I get PSWP with all the peer review and other kind of work that I do for clients, and so that's permitted. Attorneys can, your defense attorneys can get PSWP. How else do they defend you in these lawsuits if they don't have access to it? There's a voluntary disclosure to the Joint Commission or to accrediting bodies as well. But you need to make sure that if you're going to go outside that entity and disclose, you're falling into an exception. And typically, legal or someone will be involved in making sure you're making a proper disclosure or whether you have to make a disclosure in the first place. Okay. I'm now going to turn this over to Ellen, who's now going to do a deep dive into the patient safety evaluation system, what it means, and the impact on policy development. Ellen.
Thanks, Mike. I really think patient safety evaluation systems are incredible. And I didn't always believe this. I kind of thought it was a paper exercise. And I think I owe Mike a lot because he would keep calling me up and saying people aren't taking advantage of creating this safe space for learning. And I think a lot of people in the field don't really understand patient safety evaluation systems. I see them probably as one of the biggest opportunities in healthcare organizations. This is your opportunity to define what your safe space for learning is in your organization, where you do voluntary patient safety, healthcare quality, and improving outcome work. And we know a ton of it goes on, and yet I can tell you, I bet you if I queried 5 organizations, they'd say, oh, yeah, we've got it. It's our event reporting system. The event reporting system is the tip of the iceberg. And if that's what yours is, I highly recommend looking at the one that Mike worked on with an organization and really going back and saying, how could we do things differently and better here and really define this safe culture of learning in our organization through a robust PSES. So What is it? One of the health systems helped me years ago. They did it very concretely. They said in their organization, their PSES was a room, and it was all the equipment in that room, all the people that came in that room. They were PSES workforce when they came in. They had specific policies and procedures related to workflow of patient safety activities in that room. They had defined their physical and virtual space, but it's really up to you, and it's a great opportunity to make it so much more than your event reporting system. If somebody says to you, my PSES is my event reporting system, it's a red flag that you have a great opportunity. Next slide. So, what do you need to do to go about developing this? I've done it many times when I've led quality and safety in large health systems. It's not a fun activity, but you learn a ton. It's really inventorying what activities are we doing in our organization to improve patient safety, healthcare quality, and outcomes, which are voluntary, which are eligible to be within your PSES to be patient safety work product like Mike, and which aren't. Which are you doing specifically to meet a regulatory requirement? Reviewing how you collect data, where you do your deliberation and analysis. This is really a great opportunity to say, this is what we're doing in patient safety, and this is what's voluntary that we're doing. And we're going to really switch it from being, say, for example, peer review, an activity that many physicians hate and have told me that they could never learn a single thing from it, to peer learning, and really hopefully make an impact in making healthcare better. Very important to make sure that as you're documenting your PSES, you really think about the security and confidentiality of that data. I believe patient safety work product should receive the same deference and respect of PHI, and many times it contains PHI. But this is really critical data. It may impact somebody's career. We really have to treat it with the deference that it deserves. Next slide. This is a example of an inventory form that I've used. So going through each activity that you do. So let's take peer review. What is the main purpose for peer review? It truly is to improve patient safety, healthcare quality, and outcomes. Is there an external obligation? I think probably 80% of the peer review going on in healthcare organizations, there's not an external obligation. You have your required OPPE, FPPE, but a lot of this you're doing to make care better, and it's eligible to do it in a safe learning space. Peer review in my mind, but again, everybody defines this how they believe the work is being done. I believe an event happens, deliberation and analysis happens. I would highly recommend that that's a PSES activity, that peer review happens within the PSES. I think this is very valuable data to report to the PSO, and it's really up to organizations to decide if they want to report deliberation and analysis to the PSO. We'll talk about that more a little later. If you're collecting things like event reports, etc., that does need to be reported to the PSO. And Michael talked much more about the pathway. Next slide. This is your opportunity. I can't tell you, or Mike can't tell you how to document your PSCS, what activities you want in it, but it's really taking it through a risk tolerance test. How risky is this data? Is the effort to make this PSWP worth it? Will we see improvement? And then putting your items in the upper green column and doing it. There were cases a couple years ago that came out that said visitor, workman's comp data could be protected. I was talking to one of the general counsels that I work with and telling him that, and he said, "Yeah, that's great. But I have other ways to protect that data. It's not high risk data for me. I insure for those types of things doing it. I'm not going to lose my intention from patient safety activities on visitor and workman's comp data." Now, your organization may view that totally different. That's why you have to do your individual risk tolerance test. Next slide. So really important when you're developing your PSES to be very specific, because it's really nice when something happens and a court is questioning it or CMS is wanting to see documents to point to your PSES policy and say, this is patient safety work product. On the other hand, you can't, there's so many activities going on in healthcare organizations. Some you'll probably never find out about until it's too late. So you want to have a catch-all to say that it's all these things and others. So really ensuring that you're very concrete but broad. Um, Again, we're going to talk a little more about the PSES and a lot of the activities that MSPs, physicians are involved in, a lot of the committees, and how those can be managed as PSWP when they also serve some regulatory responsibilities. And I'm going to turn it back to Mike.
Yeah, if we can just go back to that last slide, Sharon. Um, so carefully describe your PSWP pathway. Um, it's very important to identify what are you reporting to a PSO, and it's usually an event report, incident report, could be your RCA, and what you're treating as deliberations or analysis. Okay. There's an appellate court decision in Illinois called Daly versus Terrell, Daly versus Ingalls Hospital. It's a med mal case. It's a great case if you're interested in looking at a court, an appellate court that evaluated the claim of privilege in a med mal case. The court reversed the trial court in Daly and found that the incident reports that were sent to its PSO were privileged and confidential patient safety work product. Okay. And so you don't have a lot of reported cases around the country. We actually have educational sessions that, drill down on some of the key case law, the litigation lessons learned, particularly when we're doing educational programs for inside and outside defense attorneys. Unfortunately, many defense attorneys don't know anything about the act, therefore don't know how to defend against a discovery demand, which is why we do these educational programs. Um, and so that court identified that there's, the reporting pathway as well as the deliberations and analysis. Next slide. Um, and another important case is the Rumsey case. Rumsey was involved a missed MRSA infection that led to permanent injuries to a patient. That case was evaluated by an infection control committee, generating reports, analyses, obviously committee minutes. The plaintiff sought access to those that work product, as well as wanted to depose the individuals at that committee. And a federal district court judge, and looking at this med-mal case, was there on diversity, said that's the epitome of what is privileged patient safety work product. And allowed, denied the plaintiff's motion to compel the discovery, and also did not permit the deposition of those individuals beyond the facts. Okay, but the analysis, the discussions, the reports, all of that was considered patient safety work product. Moreover, the PSO, and this for the Guthrie Clinic, happened to be Vizient PSO, now Preverity. And the court said, yeah, the report that Vizient had produced also was privileged and confidential work product. Handing it back to Ellen.
So this is an example of what some of our providers do. Even the same report, your event report, Parts of it may be just reported data, and other parts are deliberation and analysis within your PSES. So the first part of this event report I'm showing here, hopefully if somebody falls, all this data should be in the medical record. So basically this could tell you Mike Callahan fell on May 1st. That's it. This is could potentially meet CMS or your state's requirement, depending on your state, for event reporting or incident reporting. On the other hand, we want to know so much more because we want to prevent that event from happening again. And that's where the Patient Safety Act comes in and the deliberation and analysis. Well, tell me exactly what kind of event, how did the event happen? All the subjective information. How could the event be prevented? All that's non-PSWP or PSWP, I'm sorry. Organizations will send the entire report to us because it's valuable for learning and feedback reports, but it's really important that they know when CMS comes in, I can show you the left side, the medical record type data. I can show you the falls I had for the month of May. I can take you to those medical records, but my deliberation and analysis stay confidential. Next slide. So there's several models for conducting a PSES. You'll see here, these are all some of the standard committees. I know there's so many more in your health organizations, but many of these committees are required for regulatory purposes. They have a standard agenda that you can pretty much walk from case to organization to organization and see the same exact thing. But occasionally, and I think prior to the Patient Safety Act, sometimes when I worked in organizations, we had a really difficult issue we wanted to discuss because we thought there was a real big opportunity to improve care. In those days, we would call that medical executive session. Today, I would call that PSES session. Some organizations siphon those discussions off and have it in a dedicated PSES space. Next slide. Other organizations may bifurcate each committee and they will have a PSES space. I personally like this model better because if you're going to go into detail on a case and how can we improve this, you want as many of the right experts in the room with you, and not you can't get everybody at every meeting. So everyone can pick what works best for their organization, but thinking about it from a privilege and confidentiality perspective, if somebody says, CMS, Joint Commission, I'd like to see your P&T minutes, here's my P&T minutes, but they don't get access to, which should be totally separate, my PSES component of my P&T minutes. So just something to think about. But again, the organization has to meet their regulatory obligations outside of the PSES. But there's so much they can do within the PSES to improve patient safety, healthcare quality, and outcomes.
We may want to move through this a little quickly so we get to the other materials, especially your stuff at the end, Ellen.
Okay.
This is simply some language lifted from another health system PSES. Okay. And again, the purpose of the PSES is not just to be able to assert the privilege, it educates the internal workforce as to what are we collecting? How are we collecting? How are we sharing? And so this is much an educational tool that identifies those processes for workforce members as it is to demonstrate to a court that you're not making it up. You know, here are the components of our PSES.
We can probably skip over this slide
Yeah. I think the one
on
that's
through.
that useful, and then educating too their internals of what's not PSWP. And this is kind of taken from the statute. So again, it's an educational tool. I think look at the next slide.
And
This,
Mike,
yeah, there we
going
go.
back to that slide, though, the question I do have is probably your grievance activity would not be PSWP, but you could send that to your PSES and conduct deliberation and analysis, which would be PSWP. And you probably want to document that in your PSES.
Agreed. And here is just some examples of committees. When you think about all the committees you have within your health system, this is just the tip of the iceberg. Okay. And the whole purpose of this is to say these committees are involved in efforts to improve patient safety, reduce risk. Okay. So the activities, the analyses, the minutes, the studies, the reports generated within this committee structure is PSWP. And so you will see this in the example policy that we're sending you. So.
And organizations need to figure out, though, at the same time, how you meet your regulatory requirements and then do your activity to improve quality, safety, and healthcare outcomes separately within your PSES. Next. Here's an example of OPPE. Again, I've heard many organizations say that OPPE isn't a useful activity. I think there's great opportunity with OPPE to really make a difference for providers. What I would dream to have happen with OPPE is that there's a peer learning space within the PSES for OPPE where affiliated providers could look at each other's performance, work with one another, leadership in the area to improve their performance on those outcomes. If at some point the organization decides we're going to use one of those indicators for reappointment credentialing, that could be done outside. Also, if then there's a trigger, we have a problem case, the FPP. Depending on your state, you may make a decision to use the Patient Safety Act, or many organizations choose to use state laws so that they can demonstrate to regulators that they are meeting the obligation. And typically, there's only a handful of these cases a year in healthcare organizations. Next slide.
Okay, so we're now going to talk about, and the reason we created this slide, these next three slides, is when we refer to the term peer review, it's inclusive of so many different kinds of activities. And all of you are familiar with these activities. Many of you engage in these activities, or they're certainly engaged within your organizations. And so when you look at each of these bullet points, the thinking is, okay, what committees, what analyses, what studies, what reports, who gets involved in these activities? Again, because, when you do an FPP or OPPE, relating back to what Ellen said, your criteria are not going to be privileged. But, if Callahan's on an FPPE because everything else has failed, um, and you wanted to monitor and analyze my compliance, that analysis can be PSWP. Again, it's up to you. You get to design what is or isn't included. Next slide. Again, just other kinds of what I would view as peer review activities. And all of these activities are efforts to improve patient safety, reduce risk, right? So who's involved with these? What committees? What reports? Who do you use from the outside to assist? And these are all things you should be looking at because it should be triggering. This is stuff we can be putting within our PSCS. So I want to quickly go through this, and some of the stuff we're going to have to just leave for you to take a look at. Short answer is, can you use PSWP in peer review and disciplinary matters? The short answer is yes. Hopefully, you've tried everything else before you get to a point where you've got to suspend or terminate a physician's medical staff membership and clinical privileges. Some of the examples are set forth below. But keep in mind, there's a downside to that. These peer review statutes, next slide. You can go to the next slide too, are double-edged swords, meaning information that you're used in a hearing, for example, to take Callahan's privileges away. What's great is if I file a lawsuit against you and want access to that entire administrative record, right? Um, or I want to see the quality files of all the doctors in my department because you're saying, my quality was poor, and I'm saying you were discriminating against me based on age. That Callahan cannot access information that's PSWP to bring and introduce that into evidence to prove up my age discrimination claim. At the same in the same instance, though, you can't introduce it to defend yourself. Okay, you need other information to defend against that age discrimination claim. So it's a double-edged sword. That's true of your state statute. So really, you need to decide collectively: do you or do you not want to use PSWP in disciplinary hearings, for example? The law allows it, but you may decide not to do it. Some systems get split on this particular issue. Next, I'll keep moving here. Uh, So one of the issues that we talked about before is the distinction between use and a disclosure. Okay. So can HR, can risk management, even people that only deal with claims and litigation management, can they get access to PSWP? Could they sit in on meetings that in which PSWP is being discussed? The answer is yes. It's a use. Okay. It's an internal use that allows them access. Okay, next slide. But what they should versus the disclosure, okay? Um, Sharing PSWP with HR and risk is considered a use. Next slide. But you want to make sure that if HR is, and again, your decision, if HR and or risk dealing with litigation claims management is accessing just to get the facts, figure out what's going on so that they can do their own job, they need to create minutes, notes, investigations outside of your PSES. That won't be privileged information. That can be used for employment purposes. It can be used for monitoring litigation. Okay. So you don't put PSWP into an employee's file because, again, you can't use it. Next slide. I think just for the sake of time, there are some other slides here. And again, there's always never enough time to discuss what we'd like to. I want to jump to Ellen so we can just, these are some next slides are just some FAQs, some questions that are pretty straightforward that you can, review on your own. Let me stop here quickly. There's a May 2016 guidance issued by HHS, which specifically says that government agencies cannot require providers to turn over PSWP, but you must otherwise demonstrate compliance. Okay. So you do that through non-privileged information, give them your policies, the procedures, the medical records. Usually that's enough to demonstrate compliance, okay? But just know that they cannot require you be at the state, your Department of Public Health, or CMS. We have a presentation that does a deeper dive in terms of how you address those things, but that's beyond the scope of this presentation.
And as you prepare your PSES, it's really important to think through how will you prepare to meet the regulators when they come in, that you have the adequate documentation, you're doing your job.
Absolutely. Next. This is you, Ellen.
Again, just really figuring out what you want to go within your PSES so that if you're doing peer review, there's a great opportunity to do peer learning multidisciplinary in a PSES, really taking all these things and saying, how can we learn from them rather than it being everybody trying to protect because they know of the consequences of peer review actions. And then meeting your other regulatory requirements with other obligations. An important one is state RCAs. Organizations typically will fill out their state RCA form and send that to the state, but there's an opportunity to go within your PSES and do a comprehensive, thorough, and credible RCA that can drive improvement in your organization. Next. This just is an example of how you might consider reporting something like peer review to the PSO. The PSO doesn't need to know what peer you're looking at. It's really more about that this event happened, the event is reported, and then what did we learn from this event, from all the reviews that we did? Next slide. This just, again, let's say you're in a committee, you might be looking at billings, claims data, you may want to compare yourselves to other providers. If this is done within the PSES, the data, your deliberation and analysis are privileged and confidential. The billing and claims data isn't. I think it's a valuable way to look at really sometimes difficult information and identify as an organization how to improve. And this data can be used freely within the organization, but if anyone shares it outside the organization, there's civil monetary penalties. Next slide. This one, just as we are all entering an AI world, as you're documenting your PSES, obviously any AI tools that you use need to be HIPAA compliant, but really thinking, how's this AI tool going to interact within my PSES, and are its outputs privileged and confidential? And that's probably for a whole nother day.
All right, so we got through it. And I have answered some of the questions that Sarah has also shared with the group, but um,
Yep,
any
you have.
other
Yeah, we do have some
questions?
good questions. Thank you both so much for sharing that information. So there's a question about, is there a recommended statement that should be placed on documents that are identified as patient safety work product?
And one of the slides that we quickly went over, we actually provide some recommended language.
Perfect.
Um, and by the way, as we said before, that document in question might also be privileged under your state law. So many of you probably already refer to certain minutes or documents privileged and confidential under the Illinois Medical Studies Act or whatever your state statute is. So you may be actually adding both a state reference and a Patient Safety Act reference. Know that the failure to include such language is not determinative. It's not a requirement. It's just a way of putting people on notice that, hey, this is a privileged document. So we got to treat it as privileged, consistent with our policies.
Perfect. So we have another one about an organization who's working on increasing just broad organizational learning from safety events. And so for events that are submitted to the PSO, they're wondering if they're able to label published sort of safety stories as PSWP, as they are considered a specific function within their patient safety activities. So are they,
Sure.
are they able to label those published safety stories as work product?
You can, yes. Well, a couple things I would say is if it's patient safety work product, you can use it freely throughout your organization. I'm not quite sure what public means because it may be a disclosure if it's shared outside the organization, but there's definite ways to design learning across the entire organization from cases like that, Mike.
Yes, no, absolutely. Again, that's the affiliated entity disclosure exception where you want to use that information for shared learning. Okay. But again, you want to try to capture that activity within your policy. Now, the reality is your policies need to be updated because every day you have a new committee, you got a new report, you have a new analysis, and not all PSWP is reactive, meaning reacting to an adverse event. Um, we have a client that's got a radiology group that's now in a proactive uh, initiative to evaluate certain outcomes on their reads. Okay. It's not in response to any litigation. They're just trying to improve their readings and the reviews of those. Well, that's not exactly in the PSCS policy, but they're within the documentation of that proactive initiative. They are saying privileged and confidential under the Patient Safety Act, so they can at least have that documentation. Your PSCS policies aren't going to cover everything, all right? Because everything changes. Moreover, you might have a system policy, but your individual hospitals probably have different committee names, different reports, different analyses. Okay. So some systems have a supplemental PSPS policy for each of those affiliated entities simply because the activities are different, the committees are different. Also, an easy way to expand the protections, systems have QAPI plans, they have quality plans. We cross-reference in the PSCS policy to the system quality plan. Okay. And to the extent the hospitals, one system has a quality plan for each of their hospitals, we cross-reference to those policies. And now we suddenly expanded the scope of what can be privileged exponentially, right? Because they're now included, within our PSCS umbrella policy. So simple ways of expanding the scope of what could be protected.
Great. So another quick question just about wording. Is it important to differentiate documents and emails and label as PSWP versus labeling as privileged and confidential records and proceedings of a medical staff peer review committee?
Well, again, that last statement is kind of generic. Okay. Um, so it certainly can be protected. It could be protected under both state law and federal law. I think it's better to reference the statutes. So I would add a tag on to that last statement under the blank state law and under the Patient Safety Act. Okay. But again, that should be reflected in the policy, right? So that's really kind of where the reference, should be identifying those peer review committees and activities within the PSCS policy.
I
Right.
think it's also important to recognize that this information is created in the PSES. If you're doing peer review outside of a PSES or an RCA outside of a PSES, that is not privileged and confidential, and it can be reported to a PSO as copy, but the original can never become patient safety work product.
Got it. Okay, another quick question here about physician groups. So physician groups were also mentioned to be provider entities that are covered under the Act. So could you just elaborate, as these will be physician employer and will get full access to privileged peer review data. So as department chairs, we're told not to share this at all with employers, but with this channel, this information can be shared. Further, even for sharing, it is told to the medical group that physicians need to sign a release of information agreement in the first place.
Okay. That's a complicated question with a number of
Yes.
points. Number one, you don't want to give PSWP to HR. Okay. Again, because they can't use it to defend themselves because it's not admissible. So HR will create their own documents, their own notes, their own investigations outside of the PSDS, and that will go into the employers. In terms of disclosure of PSWP, I just had this question from a client today that wants us to come up with language because under the Act, if Dr. Callahan, let's say CMS comes knocking on the door as a result of a patient complaint, and you say, well, we're in a PSO, it's PSWP, and we want to know who that doctor is, okay? And you try not to give the doctor's name, you try to give non-privileged information, but if push comes to shove and you haven't demonstrated compliance and they need to know Dr. Callahan's name, Dr. Callahan has to authorize the disclosure of his PSWP. Now, what some facilities will do is they'll get prior authorization in an employment agreement or in the appointment reappointment form that says, hey, as a condition of medical staff privileges or employment, you have to agree that if requested, you will authorize the disclosure of your individual patient safety work product. But when that event actually occurs and you go to Callahan and say, look, Mike, we try not to give them your name, we don't have a choice. You remember that as a condition of membership or employment, you agreed you would sign this written authorization. you would have to get Callahan's written authorization, which has to describe why is it being disclosed, for what purpose. And that's a requirement under the Act. Okay.
Gotcha. So there's another one. We've just got a couple more, so we'll just go a couple minutes over here to address these. But there is a question then that sort of relates to this, which is, so let's say organized medical staff and HR receive the same behavioral concerns regarding a physician. Are you saying that HR cannot use that in situations such as that they don't have access to the patient safety work product, or they can't use that
They,
in
they,
situations such like will we renew that physician's contract? So if they're looking at doing that contract renewal.
again, it's a use. Okay.
Yeah.
So they can access it, right? But you don't want to put the PSWP into the employee's file. Okay. First of all, it's probably privileged under state law as well, not just under the federal law. So yeah, they can access this because there's facts, and sometimes HR is going to identify issues which they need to share with quality. So it's a two-way street that can work. But again, HR has to create its own pathway, its own notes, its own interviews, and put that in the file. But they can look at the PSWP that was identified for that disruptive physician, that impaired physician, et cetera. So.
And Mike, if it's the only proof, there is the dropout provision if an organization wants to take advantage of that. They can't drop out their deliberation and analysis, but if a report came in, an allegation of abuse or something, and the organization felt it was the only source of information, they could make that decision, documenting the date that they remove it from their PSES.
Right. So that's not an uncomplicated concept. But if
Hmm.
you're using the reporting pathway, okay, as opposed to deliberations or analysis, because once it's D or A, you can't drop it out. But if it's a report that you would otherwise have maybe sent to a PSO, okay, but you haven't because you want to have documentation of what you did in compliance, or you met a reporting requirement, you can drop it out before it gets reported to the PSO. It's no longer considered privileged patient safety work product, and then you can submit that report to the state or to the feds, or whoever is demanding it. That is a possibility. It's not used very often, but it is an option under the Patient Safety Act.
And we do have one last one here. Somebody keyed in on, you mentioned a separate presentation for addressing requests for PSWP from regulatory bodies. And so we have somebody asking where could they find that, because they'd love to see that information. So maybe
It's a
a
great
follow-up webinar.
presentation.
Yeah, we have that. We have a presentation that we can certainly send to that individual, or at some point, I think we're trying to make other presentations like available on our website. We're still kind of pulling that together, I think. But that would be one that, or a presentation. So a couple things before we leave. Some just quick takeaways. One, you also go back and look for your PSES policy. Okay. You should look to see it. You should then compare it with the one we're sending you, because you will see a stark difference between them. Share that with internal people. Share these slides internally to help educate folks. And if you're interested in other educational programs, as I said, we do a lot of educational programs for outside defense attorneys that don't know anything about the Patient Safety Act. Or if you're interested in any policy reviews, we're here to help. So.
Great. Thank you so much both for sharing your knowledge. We appreciate it. Thank you all for attending.
Thank
Have a
you.
great day.